At BLM, we are keen to make sure you understand what to do if you are ever involved in a civil trial and to answer any questions you may have. Please watch the video which follows to find out more. We also provide further material for you to download and details will follow at the end of the video. If you have any questions, please do not hesitate to get in touch. Please watch our other videos in the What If series for further information on legal know-how for clinicians.
What do we mean by the civil court and who decides a case in the civil court?
It's important to be clear that the civil court, whether it be the county court or the high court, is not a criminal court and is not a tribunal as may be found at the GMC or at an employment tribunal. There is no jury and the matter will be decided by a single civil judge, either a circuit judge if it's in the county court or a high court judge if it's in the high court.
Who are the key players in a civil court trial, whether it be in the county court or in the high court?
In court, the judge will sit alone at the front and will hear arguments from either side. The judge's clerk will sit just in front of the judge and will ensure that an audio recording of the trial is made. The parties' barristers sit facing the judge on either side of the courtroom. They are there to orally present the case for the party they represent, to ask any questions of the witnesses and to, importantly, assist the judge with any questions that the judge may have. The solicitor for each party will sit behind counsel. The solicitor has full, detailed knowledge of the case, having prepared all of the papers that the barrister has considered. A solicitor will not orally address the court, but is there in court to assist the barrister with the papers that have been prepared. All civil court trials are public hearings, and there is a public gallery, and any member of the public, including the press, can sit in this gallery.
What is the setup at court and what facilities are available?
As soon as you are through security, you will need to report to the court usher, who will take your name and will direct you to your legal representatives if they are already in the building, and will also point you to the courtroom. The availability of Wi-Fi is very limited across the courts and photocopying facilities are scarce. Therefore, if you have any key documents, it's important that you provide them to your solicitor prior to the court hearing.
How do I give evidence and how do I address the judge and the barrister asking me questions?
When you are called forward to give evidence, you will be called forward by the judge and the clerk to the court will ask you to swear the oath or affirm. The wording for the oath or affirmation will be provided to you and you will be asked to read this out loud. If you wish to take the oath, the court will have the available relevant religious book. Please make it clear to the usher and your solicitor beforehand whether you wish to take the oath or affirm, in order that the necessary arrangements can be made. Witnesses are often anxious to know how to address the judge when answering questions. This depends largely on the level of judge who will be deciding the case. If the matter is dealt with by a High Court judge, you will need to address the judge as "My Lord." If it is before a circuit judge in the county court, you will need to address the judge as "Your Honour." There may be occasions where a district judge will hear a trial, particularly if the case is of a lower value, in which case you will address the judge as "Sir" or "Ma'am."
What is the general running order of a civil trial?
In broad terms, the trial will start at 10:30 a.m. and the judge will sit until 1 p.m. Then there will be a lunch recess of 1 hour and the judge will resit from 2 p.m. until 4:30 p.m. It is not, however, hard and fast rule, and some judges may sit early or late to try and hear evidence throughout the day. The case will start with the claimant's barrister making an opening submission in the case. The defendant's counsel will not make an opening submission. Following the opening submission by the claimant's barrister, the claimant will call their first witness, who will usually be the claimant themselves. After the claimant has given evidence in chief, that is to say, given his or her own evidence, they will be examined by their own barrister and then cross-examined by the barrister of the defendant. Following this, there will be an opportunity for the claimant's solicitor to clarify any points that have arisen during the cross-examination. Throughout all of this, the judge can and probably will ask questions. When the claimant has finished their evidence, the next factual witnesses will be called until all the claimant's factual witnesses have been heard. Thereafter, the defendant will be able to call their witnesses, and it is at this point that you will be called forward.
What will happen when I am called to give evidence?
In the witness box, you will have with you the trial bundle of all the documents that are relevant in the case and which have been agreed between the parties. Both side barristers have exactly the same bundle, as will the judge. The bundle will include a copy of your statement. At the commencement of your evidence, you'll be taken by your own barrister to your statement that you will have previously signed, and you'll be asked to confirm that this indeed is your statement. The signature is yours, and this stands as your evidence in chief. It is extremely important that your own statement is in your words and has been checked when you sign it initially. If you are wishing to rectify errors in your statement at trial, not only does this not look good, but it attacks your own credibility as a witness. Therefore, if you take your time to ensure that the statement is factually correct at the outset, you will avoid any problems or any issues in relation to your credibility further down the line.
What is cross-examination, and how can I best prepare myself for this?
The aim of the claimant's barrister's cross-examination is to test your evidence. You may be asked leading questions that often appear to require a yes or no answer. This is a tactic used by your opponent's barrister to put their case to the judge and to essentially try to catch you out in relation to your evidence. The barrister is seeking to test any inconsistency in your evidence and to see whether there is anything in your evidence that is inconsistent, not credible, or anything that you are unsure about. The skill of a barrister is often in trying to be able to carefully take a witness through their statement and therefore lead them into giving evidence that suits their own case. It is likely that you will be asked questions repeatedly, but asked in different ways, particularly if your opponent's barrister wishes you to make a certain point. They are looking to elicit a response from you that helps their case. It is extremely important to take your time when giving answers. You must listen carefully to the question and ensure you understand it. Take your time in providing answers and do not jump in with an answer. It is important that you do not interrupt questions or interrupt the judge and give your answers respectfully. Give full and detailed answers, but do not allow words to be put into your mouth by your opponent's barrister. This is your evidence, so it is important for you to remain cool, calm and collected at all times. If you don't understand a question, then simply ask for it to be repeated or clarified. Following cross-examination, your own barrister may have further questions in re-examination to clarify certain points, and throughout the whole process, the judge may and probably will ask questions. One matter that is important to note is that while you are giving your evidence, you are unable to be advised by your solicitor or legal team. Therefore, if you start giving evidence before the lunch break, for instance, and then the court breaks for lunch and in the middle of your evidence, then you will not be able to sit with your legal team during that lunch hour, and you will be asked not to discuss the case with anybody at all during that period. Essentially, you're still in the witness box, figuratively speaking, of course.
Who are the experts in the case, and what is their role in the proceedings?
After you and all the defence factual witnesses have given their evidence, then the experts will go into the witness box, and again the claimant's expert witnesses will go first, with the defendants going after. Again, the claimant's barrister will ask questions of the experts, and thereafter there will be cross-examination of the experts from the opponent's barrister. Then the defence experts will go into the witness box.
After the hearing, what happens next? And when can I expect judgment to be given?
At the end of the trial, both sides will make closing submissions regarding their case to the judge and will use this to try and persuade the judge around to their way of thinking. It is usual for the defendant's barrister to go first. Often, both legal teams will submit written skeleton arguments in addition to the oral closing submissions. It is also important to note that a judge may not give judgment immediately. It is not unusual for the judge to reserve judgment for another day, which can be significantly later.
After judgment has been given, your solicitor and legal team will advise you on the reasons the judge gave a certain judgment and the ramifications of it. It may well be that your legal team wishes to consider an appeal, but this is an issue upon which you will be advised at the time. We hope you found our video informative. To download further material, please visit the link on the screen now or contact a member of the team. Thank you.